Um, okay, now we're recording. I go back to share. Okay, let us begin. So there is the title, Limitation Proceedings as an International Forum Selection Method in Collision Cases. It's a fairly long title, but fairly accurate about what I intend to cover. This is something that happens very often. I have been involved in several cases. You heard in the introduction that I work as a consultant to firms in practice as well as teaching. And I've worked on several cases that have this quality about them. And they're usually very big cases involving a lot of money. And so this technique that I'm about to describe is one that is very often used in collision cases, particularly serious collision cases. Okay. Now, why is it not? Wait a minute. There we go. So if I take my slides one at a time, we start with, I'm going to start with an introduction that just sort of describes the whole of what I'm going to cover. And then we'll sort of take it step by step. But a little description of the whole thing is to start with the observation, fairly obvious observation, that I can highlight the text as I'm speaking. That if we start here, the collision cases are very often involve ships of different nationalities. Now, of course, if there's a collision between two Chinese ships, it's likely that the case is going to get litigated in China. But if there's a collision between ships of different nationalities, it's not so obvious that it's going to get litigated in one country rather than another. Now, to use a term that actually, this term here, natural forum, actually comes from, it's used most in England, but what the notion of a natural forum is that there may be an obvious place where a claim may be brought. And I will show you an example of that in just a little while. But for example, if there's a collision between ships, whatever their nationality, if those ships collide in the territorial waters of a particular country, so they collide near to the coast, well then the country that they're near when the collision occurs may seem like the natural forum, not because of the nationalities of the ships, but because of where the collision took place. Like the evidence will be there if the collision took place in territorial waters, particularly if one of the ships sinks, then the evidence in relation to the collision will be right there near the coast of that country. And that country is then the obvious place for the claim to be brought. But the owners of the ships may not want to litigate there. It's natural in the sense that, you know, it's the closest place, that country's law may apply to the collision, but the owners and the insurers of the ships may not want to litigate there. And just to give you a small example of a case that I worked on a few years ago, there was a collision between two ships in territorial waters in Vietnam. Vietnam was very much the natural forum because everything happened fairly close to the shore in Vietnam, but neither sides, neither ship owner wanted to litigate that case in Vietnam. And this decision is often run by the insurers of the ships because, particularly if it's a very expensive collision, it's the insurance companies, the P&I clubs perhaps, who are making the decision about where to litigate. And even if if there is a natural forum, maybe the parties involved do not want to litigate there. Now, if the collision occurs outside of territorial waters, in international waters, or the high seas as we call them, outside of national territory, well, then there's no natural forum because any country in the world has jurisdiction to consider a case involving a collision in international waters. And if there's no natural forum in the sense that I just described, this case could be brought anywhere. I mean, as in any country in the world. And again, to highlight this point, where am I? What am I doing? Here I go. Not with that, with this. Hold on. I'm trying to, this. Yeah, this bullet point here. As I'm guessing you know or are learning, that you can establish jurisdiction over a ship in any country that it visits by arresting the ship when it visits that country. And so ships travel around the world, and it's possible to establish the jurisdiction over a ship by arresting it in a country. But once again, the law in that country may not be the one that the ship owner or its insurers want to sue in, because the law may not be favorable to them in that country. And so what happens in practice is the natural forum, or the forum where you may be able to find the ship, it may not be the one that is best for the ship owner when it looks at its own interests. And so what happens is that after a collision, this point here, owners and insurers often usually prefer, I would say actually, to choose their forum. The forum being the place where they want the case to be heard. And they do that by starting limitation proceedings in the country of their choice. So even if the ship owner thinks that there are claims going to be made against it, it still is able to choose where the claims are heard, because normally it's the claimant, the person who's making the claim, who chooses where they're going to claim. This is a way in which the person against whom the claims are going to be made can choose where that's going to happen. And they do this by instituting limitation proceedings. And the last bullet point is that if there are two ships involved, there may actually be more, as there is in one of the cases I'm going to show you. Each ship owner may choose a different country. If each ship owner institutes limitation proceedings in a different country because they've chosen different reasons why that country is more favorable to their interests, well, then you have the possibility of parallel claims. Two cases about the same collision taking place in different countries. And that is particularly possible when you have a high seas collision, where there's no natural forum, where the collision occurs in outside of territorial waters. Okay, so that's the introduction. That's the ground that I'm going to cover to describe what goes on in these cases. For some reason, it takes a very long time to change pages to my next slide. Oh, no, there we go. Oops. And so before I begin, I thought I should start with a simple outline of how limitation works. Now, my guess is that some people in the lecture theatre know very well how limitation works because you'll have studied it. But in case not everybody there has already covered how limitation works, limitation proceedings work, I thought I'd start with a simple outline. And if you have heard this before, well, it does no harm to have it refreshed for you. And the way that it works is that the ship owner brings the proceedings as the plaintiff. Now, as I said, even if it thinks that it's going to be the defendant, even if it thinks that claims are going to be made against it, it can proceed as plaintiff. And the argument in those limitation proceedings is that if I am held liable, that liability should be limited in amount. And that if is quite important. I'll clear it out the way. That if is quite important because invoking limitation is not an admission of liability. So the ship owner is not admitting that it's liable for what happened in the collision by invoking the right to limit. The lawsuit seeking to limit its liability says, if I'm held liable, then my liability is limited in amount. Now, most countries require a limitation fund to be constituted. And I'm going to talk a lot about the limitation fund. And what the limitation fund is it's a sum of money or a guarantee of a sum of money that's paid into court. So whichever country the ship owner or its insurer institutes these proceedings will say, well, if you want to limit your liability in this country, you must pay into court the amount of your limited liability. And I said this can be done either by payment into court or by a guarantee of payment. And in many cases, particularly if the ship is entered with a P&I club, the P&I club will simply give security by way of a guarantee of payment. But however it's done, there has to be a fund. And then all claims are made against the fund. And what happens is that the limitation proceedings are then usually served on the potential claimants. Now, this can be very confusing for lawyers who haven't been engaged in this before, because if you think you want to make a claim as a result of this collision, but then you're served with proceedings, it feels like you're the defendant, and you think, no, wait a minute, I want you to be the defendant. I want to hold you liable for this collision. So this can sometimes be confusing because it feels sort of upside down, but that's the way that it works. The proceedings are usually served on the potential claimants, and then they're usually advertised as well, so that potential claimants know that a fund has been constituted and that they have to claim against that fund. So if the ship owner knows who might make a claim, it tells those people. And just in case they don't tell everybody who might want to make a claim, they make this advertising as well. And the advertising is usually in trade journals. Now, this word here, concursus, is a Latin word. I don't quite know why we use the Latin still, but we do. And what concursus means is bringing together. And that is the effect of limitation proceedings, because claims can then only be brought against the fund. If the ship owner has constituted a fund, any other lawsuits about that collision must cease, at least in the country where the fund is constituted. Right? And I'll talk about the international effect in a little while. But so, for example, if you institute a fund in the United States, if you constitute a fund in the United States in limitation proceedings, the court will issue an order saying any other claims must now stop, and all claimants must come and make claims against the fund. And so if some of the plaintiffs, the liability claimants, have made claims in other courts in different states, for example, in the United States, they cannot continue. They must claim against the fund. If a claimant hasn't yet made a claim, it will find that it cannot make a claim. It must claim against the fund. And that is called concursus. It brings everything together. And as I said, every country's national law of limitation works like that. Now, so the simple effect of this is what the ship owner is saying is, if you want to sue me, you must sue me here. And that, of course, is what the ship owner or its liability insurer wants. It wants to choose where the claim is brought. It doesn't have to wait to see where the claimants want to sue. It chooses where it wants to be. Now, as I've already indicated in my introduction, excuse me, I gotta take a little drink. There are many factors affecting the ship owner's choice. It may not want to be in the natural form. It may not want to be in a country where it could arrest the ship because perhaps the law is not favorable there. And this is a tactical decision that the ship owner must make. And speaking as someone who's worked on cases like this is something where the owner and their insurer really rely on the lawyers to help them work out, to choose in which country to constitute the fund. And I'm going to try and describe to you the tactics of making these choices. And there are two main factors. These are not the only ones, and they don't always point in the same direction. So sometimes they do, sometimes they point in different directions. But the main tactical factors that affect this choice of where to institute limitation proceedings are, first of all, the size of the limitation fund. And as I'll show you, the fund may vary in size in different countries. So in respect of the very same collision involving the same ships, some countries may say the fund is smaller than it is in other countries. Now you may think then the ship owner is always going to go for the smallest fund because that's the least amount that it can be held liable for. That's not necessarily true though, as I will illustrate to you with some of the examples, because another factor is how easy is it to break the limit? Because as I'll show you, it is possible, in most countries at least it's possible, to break the limit is how we put it. Now what that means is to establish that the ship owner who's brought the limitation proceedings is actually not entitled to limit because of its conduct. And if the limit is broken, if the ship owner is not entitled to limit its liability, then of course it's got unlimited liability. And the ship owner doesn't want that at all, or its insurer doesn't want that at all. So it may be the case that there's a country that has a really small limitation fund, but where it's quite easy to break the limit. Now, there the factors may be pointing in different directions. And that, by the way, is quite often the case in the United States, as I'll show you. Because the limit may be quite small, but if it's quite easy to break the limit and have unlimited liability, well, then perhaps you don't want to institute limitation in that country. Maybe you'd be better off going to a country that has a much higher limit of liability, but which cannot be broken, right? So these factors do not necessarily point in the same direction, but these are the main things that the insurer and its lawyers will be taking into account. Now, a third factor can be important, isn't always, but can be if one of the ships sinks. And I'm going to give you a couple of examples of that. The question is, are wreck removal claims subject to limitation? And depending on what happened after the collision, this may be a very important question because wreck removal can be very expensive. Now, some countries, including China, say that wreck removal claims are subject to limitation. And I can show you this if I just do this and do this and then this. I hope you should now be able to see the text of Chapter 11 of the Chinese Maritime Code. Can everybody see text now rather than me and rather than my overheads? And the relevant provision is this one, Article 208, which says the provisions of this chapter, meaning Chapter 11, shall not be applicable to the following claims. So here's a provision that says these are the claims that are not subject to limitation. And I won't read them all out. Salvage, oil pollution, nuclear damage. Wreck removal is not on that list, right? And because wreck removal is not on that list, it means that you can limit your liability because it's not one of the ones where the code says you can't limit your liability. Okay? So in China, wreck removal claims are subject to limitation. And in other countries, they are not subject to limitation. Is everybody now seeing the overheads again? I think you should be, right? Yes? Okay. So that can be a very important factor in itself. And I'm going to give you an example now of a case that I spent quite a lot of time working on. So I know the details of this case, but it's quite a famous case in any event. And so I'm not using it just because I happen to have worked on it. This is a case about two ships. One was called Beoceania, and the other was called Xintaihai, obviously a Chinese ship. And they collide in the Straits of Malacca. I imagine that many, if not all of you, know where the Straits of Malacca are. They're between Malaysia and Indonesia, and it's a very, very busy shipping channel because any ships that are going from the South China Sea to the Indian Ocean have to go through the Straits of Malacca. So it's a very busy shipping channel, and these two ships collided in the Straits of Malacca. They were closer to the Malaysian side than the Indonesian side. In fact, it was quite close to the shore in Malaysia. So Malaysia was probably the natural forum, as I described it to you. I mean, if you had to choose, where the obvious place to sue about this would be, it might be Malaysia. But neither side was particularly interested in fighting this legal battle in Malaysia. Now, Beoceania sank, and it sank right in the channel in the Straits of Malacca. And so this is a little bit like having your car break down in the middle of the freeway, right? You have to get it out of there. And there's all sorts of laws saying you have to get this out of the channel, right? And so some wrecks can just be left where they are and they sort of go rusty and sit on the bottom. But a wreck like this one that's right in the middle of a very busy shipping channel, the authorities will not allow you to leave it there. And so wreck removal of the Beoceania was essential. And it was very expensive. In fact, it was so expensive that removing the wreck cost much more than the value that the ship had or its cargo. And if the insurers had had a free choice, they would have said, leave it there. It's not worth spending the money because removing it is going to cost way more than it's worth. But if the authorities say you have to remove it, you have to remove it. And so you have to incur this expense. And that's what happened with Beoceania. The owners of Beoceania had to pay to remove the wreck. Now, the owners of Xintaihai, their next port of call was Qingdao. And as soon as they got to Qingdao, they institute limitation proceedings in China, in the Qingdao Maritime Court. Why? Because as I've showed you, wreck removal claims are subject to limitation under Chinese law. Now, just to help you think this through, this is a collision where Beoceania sank. Now, that doesn't necessarily mean that it was Xintaihai's fault, though it kind of was. But obviously, Xintaihai is concerned that it's going to get sued by Beoceania because Beoceania sank, and there's this giant wreck removal claim sort of likely to come along. It can limit its liability for that wreck removal claim under Chinese law, as I've just showed you, because of our Chapter 11 of the Maritime Code. So it institutes limitation proceedings in China. Now, after it's discharged its cargo in Qingdao, it goes on another voyage. Oh, look, someone else has joined in with annotations, which is fine. You're allowed to do that. Actually, you're right. I could make this bigger, couldn't I? The next voyage that it goes on is to Australia. And it's going to Australia to load a cargo of iron ore, if I remember correctly. And the owner of Beoceania sues Xintaihai by arresting it in Australia. Now this, just to repeat a point that I made earlier on, this case has got nothing to do with Australia. It's a collision between two ships near Malaysia. One of them's a Chinese ship. The other one was actually insured by Norwegian interests. It's got nothing to do with Australia, but Shin Tai Hai is now in Australia and it gets arrested in Australia. Why? Wreck removal claims are not subject to limitation under Australian law. And as I'll show you, the limit of liability is also much bigger. So B Oceania is concerned that Shin Tai Hai is going to try to limit its liability and thinks if we are going to have a national country's law limiting liability, we would much rather it be Australia than China. Okay? So does everybody see this as an example of how you use the limitation proceedings as a means of trying to select your forum? Now, I said, because I've got because I've worked on this case, I've got lots of pictures actually of the B Oceania, but this is a very striking one. I don't know if you can really tell because you can't see very much of the ship. But it's this is the ship's mast. Here's the ship's smokestack, and all the rest of it is under the water. It's sitting on the bottom in the Straits of Malacca, but I don't know if you can see all that well, but here in the background, here are some more ships coming up. It's I said, it's like breaking down, your car breaking down in the middle of the freeway. And so it had to be got out of there. Now, I'll come back to the Shin Tai Hai and the B Oceania in a little while, but as you can tell from just that much of it, there's a big difference between the law in China and the law in Australia. And there's actually quite a lot of differences between different countries about limitation of liability. And this is why this kind of tactical game is possible, because you can institute limitation proceedings almost anywhere, as I'll show you. And so you get to make a choice depending on those variables that I talked about. Now, there are 3 different international regimes, 3 different international conventions. One is the 1957 convention. Not many countries are party to that anymore, but some are. And the fund is there constituted by reference to the net tonnage of the vessel. Now, your navigation colleagues at DMU might be able to tell you the difference between net tonnage and gross tonnage. But net tonnage is the tonnage of the ship without the accommodation space and without the engine room space. So it's just the tonnage of the cargo carrying parts. And that means it's not all the tonnage of the vessel. And the fund is calculated by a formula by reference to the tonnage of the vessel. So the bigger, the heavier the vessel, the bigger the fund. Now, it's fairly easy to break the limit. And the phrase in the 1957 convention is actual fault or privity. And what that means is if the ship owner itself is guilty of fault, it's not entitled to limit its liability. If the collision occurred because of mistakes on the ship, then the ship owner is entitled to limit its liability. So the question in these 1957 cases, 1957 convention cases is, can you show that the ship owner itself is guilty of fault? Because if the ship owner is only responsible for what happened on the ship, things that were done wrong on the ship, it can limit. Some countries, as I said, are still party to this. I've got some there, South Africa, Israel, and Portugal. That's just some examples. Now, there is another convention, the 1976 convention, much more widely adopted. It's usually called LLMC 76. And here, the fund is by reference to the gross tonnage of the vessel. That's the entire tonnage of the whole ship. Not only does it use more of the tonnage of the ship than 57, but the the limitation amounts are much higher. So the formula produces bigger sums. So it's a larger fund, liability is higher. But it's almost impossible to break the limit. And the phrase that's used is actually used in the Chinese code as well. So I'll talk about that phrase in just a moment when talking about China. But it's much harder to break the limit than it is under 1957. So as I've said, it's not always the smallest limit that you want to go for. You also have to consider how easy is it to break that limit. So even though the limit is higher under 76, the fact that it's impossible to break that limit, that may make it more desirable for many ship owners. Now, there is also a 1996 protocol. Oh, sorry. So there are some countries that have the 1976 convention, but not this protocol. A protocol is an instrument that amends a convention, and the amended protocol convention is usually called LLMC 7696, right? The amended version. Now, these countries are just some examples of countries that haven't adopted the 1996 convention, protocol rather. And so if the size of the limit is really important, you may want to institute limitation proceedings here. And an odd one you might think is Switzerland, because Switzerland doesn't have a coastline, but yet it's got a very good legal system. And it is party to the 76 Limitation Convention, and you can institute limitation proceedings in Switzerland, believe it or not. Now, most countries have adopted the 96 protocol now. It's the same as 76 mostly, but with much larger limits of liability, and they were increased again in 2015. So now the limit of liability under 96 is much bigger than 76 and much, much bigger than 57. Many countries have adopted this, and some have actually denounced the LLMC, which means they're not even party to LLMC anymore. They're just party to 96. That becomes important kind of in just a moment. Okay, now one thing that you will need, that obviously you need to work out, is which country has adopted which of these conventions. And I actually forgot to load this up, but I can load it in just a moment. If you go to the IMO website, the IMO, the International Maritime Organization, and it has got this splendid, can everybody see an Excel spreadsheet there? Let me just make sure that you can. There is this, I loaded this in just a moment from the IMO website. And what you can see is this is a table that's on the IMO, the International Maritime Organization website, and it tells you which countries have adopted which conventions. And so if you're advising in one of these cases, and you're trying to choose between these jurisdictions, you need to know which country has adopted which convention. Whoops, I need to share my screen again. It's pretty easy to find out which country has adopted which convention. Okay, now not every country has adopted one of the conventions. So those are the different international possibilities. And you can check on those by looking at the International Maritime Organization website. But there are different national laws as well. And neither China nor the United States is party to any of those conventions. As I just showed you a little while ago, China has got Chapter 11 of the code, which is modeled on 76 convention. But China is not party to the convention. It's just adopted the provisions without becoming party to the treaty. And the limits are much lower under Chinese law than they are under 7696. That's why Xin Taihai wanted to be in China. When I say the limit is almost impossible to break, I'll now show you again the Chinese provision. Where did it go? It went here. The Chinese provision should now be on your screen. It is Article 209 of the Convention. Well, it's Article 4 of the Convention, sorry. It's Article 209 of the Code. This is taken from the Chinese Code. It's Article 209 of the Chinese Code. It says, a person liable shall not be entitled to limit his liability if it is proved that the loss resulted from his act or omission done with the intent to cause such loss, or recklessly and with knowledge that such loss would probably result. Now, what that means is you only lose the right to limit if you intended to cause the damage, or you were reckless about the damage happening. And that's really difficult to establish. And so it's much harder to break limit under the 7696 Convention or in China. Now, as I've said, in China, it is possible to limit liability for wreck removal. In the United States, it's a different thing altogether. The United States statute dates from 1851. The US is not party to any of the conventions, still has this ancient statute. And under that statute, the limit of liability is by the value of the ship at the end of the voyage. All the other regimes that I've described do it by the tonnage of the ship. But the US does it by the value of the ship at the end of the voyage. Now that limit is fairly easy to break, and wreck removal is subject to limitation. So you can see that China and the United States have done things that are a little bit different from any of the conventions. China a little bit and the US a lot different than the conventions. And this is relevant. And I'll show you an example, another example of this tactical choice. This is a collision involving a ship called the Tricolor. That's how you say this word. It's an Italian word, Tricolor. And it's a car carrier. I don't know if you know what car carriers look like, big square-sided ship. And it sank in the English Channel between England and France after colliding with Kariba. Now, a more accurate description is Kariba collided with Tricolor, because Kariba was pretty clearly at fault. And it's a little bit complicated. I don't know if you can picture this, but if I describe it, Tricolor and Kariba are heading west in this channel. And it is a traffic separation scheme. I hope you know what traffic separation schemes are. But if you don't, it's pretty obvious. It's a scheme that's used in highly trafficked channels, like the Straits of Malacca or the English Channel. There's a traffic separation scheme. And Tricolor and Kariba are going west. Tricolor is overtaking Kariba, so it's going faster. And this is all happening at night, in fog, at high speed. Not really a good idea. But that's what everybody is doing, and that's what you have to do. It's a little bit like driving on the freeway. If everybody's driving fast, you have to drive fast. Now, Clary, this third ship, is headed northbound, so it's crossing the east-west lane of this traffic separation scheme. And there's actually a kind of crossroads in the traffic separation scheme, north-south, east-west. Clary is supposed to give way to Kariba, and it's also supposed to give way to Tricolor. Right? Why? Well, again, your navigation colleagues can tell you that you're supposed to give way to starboard, you give way to the right in a crossing situation. Clary's going north-south, the other two are going east-west, it has to give way. Tricolor is also supposed to give way. to Kariba. Why? Because it's overtaking. And again, the navigation rules say that if you're the overtaking ship, you have to give way. What that means is that Kariba has the right of way. In collision talk, this is called the stand-on vessel. If you have the right of way, the other two ships are supposed to give way to you. Your duty is to stand on. And what stand on means is you keep going and leave it to the other ships to give way. And Kariba was the stand-on ship. And so it was supposed to just keep going and leave it to Clary to give way and for Tricolor to keep out of the way. But it didn't do that. It got very nervous about the fact that Clary did not appear to be giving way. And the people on the deck of Kariba, on the bridge of Kariba rather, were so fixated, so worried about Clary and the fact that they might be going to collide with Clary, that they forgot all about Tricolor that was overtaking them. And in an attempt to get out of the way, which is not what they're supposed to do, they're supposed to keep going, but in an attempt to get out of the way, they turned to starboard, turned to the right, straight into Tricolor, rams right into Tricolor, which then rolls right over. And I'll show you a picture. There it is, lying on the bottom. This is a picture like the one I showed you of the B Oceania sitting on the bottom. Here's the Tricolor. The ship is on its side, as you can see. Here's the smokestack here. Here's the side of the hull. It's rolled right over. And by the way, it was carrying a lot of extremely expensive cars. Right? So this is another really big money dispute. This is what Kariba looked like after the collision. Now, that doesn't look very good. You can see it's all smashed up. The bow is all smashed up. It's a little ship, as you can see. It's not very big. Here's the smokestack here. Let me go back to drawing. Here's the smokestack here. But this mess of the bow here, it was pretty clear that it was not going to be worth fixing that ship. So it's only really worth anything as scrap metal. So you now have to choose where you're going to institute your limitation proceedings. And if you're, and the insurers who are fairly obviously going to have to make this choice are the insurers of Kariba. Because Kariba is fairly obviously at fault here. It turned right into Tricolor and rolled it over. But this was just a mistake of the people on the bridge of the ship. There was no fault on the part of the owner. It was just a pure navigation mistake by those sailing Kariba. The owners of the Kariba, the equipment was all working. There was nothing that the owner did. It was just a bad mistake of those on the bridge of the ship. Now, the natural forum here might have been England or France or maybe Belgium, because those are the nearby countries to where this happened. But those are all LLMC 76, 96 countries, and those all have a high limit. Right? So if Kariba were to limit its liability in any of those countries, the limit would be very high. Now, as I just showed you a picture of Kariba, Kariba had very little value at the end of the voyage. Now remember, I said in the US, limitation is done by the value of the vessel, not its tonnage. And so what does Kariba do? It institutes proceedings in Han Deng's hometown, now hometown, New York. Right? Now this case has got absolutely nothing to do with New York. It's a collision in the English Channel between England and France, but New York court has got jurisdiction over it like any other admiralty court would. And why New York? Well, it's a very low limit. The value of the Kariba, much less than England or France. Now, as I told you, under US law, it's easy to break that limit, but you can only break it by showing privity or knowledge on the part of the ship owner, and that really didn't seem likely. It seemed that there was very little risk of unlimited liability. And lastly, there's no reason not to bring this case in New York, because this collision was close to England and France, but it was in international waters. It was on the high seas. And as I said in the introduction, any country has got jurisdiction to hear a case about a collision on the high seas. So there was no reason not to do this case in New York, and that's what Kariba did. And unless you know the tactical reasons that I tried to explain to you earlier on, this choice of New York as the forum for this case seems to be bizarre. You think, why would they choose New York instead of England or France or Belgium? Well, I hope I've explained to you why the insurers of Kariba chose New York. Okay, now our next question is, I said that you can sue almost anywhere, and sue in the sense of the ship owner can institute its limitation proceedings almost anywhere. And the next question is that true? Like anywhere? Do you have a completely free choice of country? Particularly in relation to a case like the Tricolor and the Kariba, which is in high seas. And the answer, generally speaking, is yes. Right? As I've said, Admiralty jurisdiction is not dependent on connection with the country. The Admiralty courts of most countries will hear claims arising anywhere in the world, particularly if it's a high seas collision. Now, so the Admiralty jurisdiction is available to you in every country that has an Admiralty jurisdiction. But there is a provision of the LLMC that appears to limit the choice, at least among convention countries. And when I say convention countries, I mean that's countries that have adopted the convention, not like China that has got the same provisions, not party to the convention. And the provision that appears to limit the choice is this, Article 11.1. And I have made, I've colored red the words that seem to limit the choice. It says, Article 11 says, any person alleged to be liable may constitute a fund, and remember what it means to constitute a fund, with the court or other competent authority in any state party, now state party means country that has adopted this convention, in which legal proceedings are instituted in respect of claims. Now that's what the convention says, LLMC, and remember most countries that have adopted one of the conventions have adopted that. It seems to say that you can only constitute a fund in a country where claims have been made against the ship owner. You can constitute a fund anywhere where proceedings are instituted in respect of claims. So it sounds like the ship owner has to wait to see where his claims are made against it and then constitute its fund. That's how it sounds. That is not how it's interpreted. The English Court of Appeal, in an important case called the Western Regent, said, no, that's not what Article 11 means. The limitation proceedings themselves are legal proceedings. So if you look at what it says you can constitute a fund wherever there are legal proceedings. And the English court said, well, you can constitute a fund wherever you bring a limitation proceeding. That's what it says. It doesn't say the ship owner has to wait until it has claims have been made against it. So yes, in effect, you have a completely free choice. You institute proceedings in a convention country, then you constitute your fund. That's what Article 11 says. So this English decision, which by the way, I mean, it's only authoritative in England, but that's accepted as being the correct interpretation of Article 11. Now, so you have a completely free choice. You can go pretty much anywhere, but you being the ship owner or its insurer. Now, the next question is, what happens if there are parallel proceedings? Because I hope you can see that if both ships in the collision are acting in the way that I've described, making a tactical choice about which country will be best for them, they may be in different countries. They probably will be, right? And so, for example, in the collision that I described to you earlier, where the ship, the collision was in Vietnam, one ship owner brought limitation proceedings in Hong Kong. The other one was in the Marshall Islands. As I've already told you, Oceania proceeded in Australia, Xintai Hai in China. Each ship, so what is a common example in these cases is that each ship owner will start its own limitation proceedings in its country of choice, right? Now, to make what I hope is an obvious point, even if each ship owner, excuse me, even if each ship owner chooses its own favored place, it is effectively forced to participate in the proceedings in the other country. And maybe it's obvious why, and in case it's not obvious, I'll say you don't want to lose the right to claim by not turning up. So just to remind you, Xintai Hai had been arrested in Australia. The ship had been arrested in Australia. So the Chinese ship owner had to participate in the Chinese proceedings. The owner of Oceania was not an Australian ship owner, but it had to turn up in China because it couldn't just let the Qingdao Maritime Court decide the case without participating, because then it might get nothing, right? So each ship is going to be forced to turn up in the other proceedings, even though it doesn't particularly want to be there because it wants to be in its own favored place. If that's what happens, and that is what happened in the Oceania, then you have two courts in different countries considering the same case between different parties. And you obviously then have the possibility of different results, and that's really bad, right? To have different courts in different countries saying different things about the same case, that's going to be awkward. Now, LLMC has a provision about this. It's Article 13. And Article 13 says, and again, I've highlighted the relevant words in red. It says, after a limitation fund has been constituted in accordance with Article 11, so if you've chosen your country, constituted a fund there, any ship or other property belonging to a person on behalf of whom the fund has been constituted, which has been arrested or attached within the jurisdiction of a state party, may be released on order of the court. However, it says, such release shall always be ordered if the limitation fund is constituted in one of these four places. First, the port where the occurrence took place, or, I'm making a mess of this, if it took place out of port at the first port of call thereafter. Now, if it's an injury claim, first port of disembarkation. If it's a cargo claim, first port of discharge. And then if it's been arrested, you can do it in the state where the ship has been arrested. Now, maybe it's not clear to you what that means. That's quite a lot of text for you to follow. But what it's saying is that if you've constituted a fund in one convention country, in one country that has adopted the convention, other countries that have adopted the convention may then release a ship if it's been arrested there, or other security like a P&I club guarantee. Those other countries, those other convention countries must release, shall always order the release if the fund has been constituted in one of these 4 places. Now, let me illustrate the effect if you haven't already got it. What that means is if the fund is constituted in one of those 4 places. Oh, sorry. Everybody okay? Still, I've got about 20 minutes left. I believe that we have about 20 minutes to go.
No problem.
Okay.
I think, Professor Davis, you can use your power to mute other users. I'm sorry.
Oh, right. Yes, I can. Let me. No, that's okay. It hasn't been a problem so far. Because I'd have to get out of sharing to do all of that, and I won't do that, right? So if the fund is constituted in one of those 4 places, other convention countries, other state parties must release any arrested ship or substitute security. Someone else underlined that. That's the important thing. If the ship has been arrested or if security has been given. Now, what happened when Shin Tai-hai was arrested? Its insurer gave security for release of the ship, a guarantee to pay, and the ship was released. What the convention says. What the convention says is that other convention must release. So if this case be Oceania, if the convention were sorry, maybe I am going to mute. Hold on. Let me see if I can do that without. No, I can't. I have to get out. So if China were a convention country, which it is not, but if China would have been a convention country, Australia would have had to release the ship from arrest or release the security. Why? Because Shin Tai-hai's limitation proceedings were instituted in Qingdao. And that was its next port of call after the collision. And if I go back to Article 13.2, you'll see that's one of the 4 places. Whoops, I need to get out of annotations as well. That's one of the 4 places, the first port of call after the collision. That's exactly what Shin Tai-hai did. It instituted proceedings in Qingdao. If China had been a convention country, Australia would not have been able to arrest that ship. Why not? Because Australia is a convention country. Now, I hope that what you can see then is that Article 13 makes that gathering of all claims in one place have an international effect, but only in convention countries. Because every other convention country has to say, no, we can't handle this case because the fund was constituted in the first port of call after the collision. And other convention countries are going to say, no, we can't have the ship arrested here. No, we can't. We must release any security. Now, this does not happen in non-convention countries like China and the United States. So it didn't happen in the Shin Tai-hai because China is not an convention country. Now, the reason why it works, this concursus effect works in convention country is, well, it's an international treaty. So the countries that have adopted it have international law obligations, one country to another. Now, obviously, equally, no country owes a treaty obligation to a country that's not in the same convention. Right? So when Kariba brought its limitation proceedings in New York, the court makes the usual order saying, no, all other proceedings must come to an end. They must all be stayed. And it was specifically held by the Second Circuit Court of Appeals on appeal that that order only had effect within the United States. It has no effect in Belgium. Proceedings have been brought about the lost cars in Belgium. Remember that Tricolor was full of very valuable cars. And this order has no effect in Belgium. Why? Because the United States is not party to a treaty with Belgium. If the United States were party to the treaty, then the position would be different. And so to make the obvious point that I've in fact already made, Australia did not owe China any treaty obligations in the Beoceania case and was not obliged to release the security given by Xintai Hai. Okay, so what happens then, right? Article 13 tells you what happens when the two countries involved are both convention countries. But what happens if one or both of them are not convention countries? And the answer is, well, then you fight about where you're going to fight. And this is actually, I'll be perfectly honest with you, it's great fun for the lawyers involved. It usually costs the insurers a lot of money and they're not so enthusiastic about it. But you then get into a fight about where you're going to fight. And in common law countries, let me emphasize again, in common law countries, but not civil law ones, there are two mechanisms that you can use to fight about where you're going to fight. Once again, one of them has got a Latin name, forum non conveniens, and there's another Latin name that I'll explain in a moment, lis alibi pendens. The other mechanism that is used, procedural device that is used, is an anti-suit injunction. Now I'll explain how they work in just a moment, but those are the devices that are used to fight about where you're going to fight if you can't rely on Article 13 of the convention, if both countries are not convention countries. And both can be and are used in cases of parallel proceedings in different countries. And both of them played a part in the Xintai Hai case in the Australian court. Now, only in the Australian court. Why only in the Australian court? Because these are common law devices. Australia is a common law country. China doesn't have this because China is a civil law country. Right? Okay, so what are they? And I could do more than one whole lecture about how these things work, but I'll scoot through it just so that you get a sense of what goes on. Forum non conveniens is basically saying to the court, you are not the appropriate court to consider this case. That's what forum non conveniens means. That Latin phrase means this is not the appropriate place. You are not the appropriate forum. This is not a challenge to the court's jurisdiction. It's actually an acknowledgement that the court has jurisdiction, but you're asking the court not to exercise that jurisdiction. And this is completely at the discretion of the court. Now, this is why civil law countries don't really get it, right? Civil law countries think that forum non conveniens is a bit weird because civil law countries say, if the code says the court has jurisdiction, it has jurisdiction and it must exercise that jurisdiction. It can't simply say, oh, I don't want to. But in effect, that's what forum non conveniens says. It gives the judge the right to say, well, even though I've got jurisdiction, I don't think I'm going to exercise it in this case. Why? Because it's more appropriate that another court do so. Now, that may be combined with an argument about lis alibi pendens, another Latin phrase, which means proceedings pending, on foot, alive, elsewhere. So if there is a lawsuit pending in another country where it's more appropriate, the court's going to say, well, I'm not going to hear this case. Why? I could, but I'm not going to. Why? Because there are proceedings pending in another country, and I think it's more appropriate that this happened there. So as I said, Australia is a common law country. This motion is available to it, and the Chinese shipowner, Xintai Hai, applied for a forum non conveniens stay in Australia, basically saying, this is not an Australian case. Right? It's got nothing to do with Australia. It's a collision between Malaysia and Indonesia. It's got something to do with China because one of the shipowners is Chinese. Right? This has got nothing to do with Australia. Please don't hear the case. It's not appropriate for you to consider it. But the court refused to stay, that is. In other words, it kept the case. Why did the Australian court keep the case? It's not clearly inappropriate, it said, to proceed in Australia. That's the Australian test. Why? Because the Norwegian owner is doing something appropriate in trying to get a higher limit of liability. The Norwegian owner of B Oceania wanted to be in Australia, didn't want to be in China because the limit of liability is higher under Australian law, and that's appropriate, says the Australian court. So I'm going to let them do that. Even though this case has got nothing to do, the collision's got nothing to do with Australia, the desire to use Australian law about limitation, that is appropriate. Okay, so that's what happened in B Oceania. The other, that's a very fleeting example of how forum nonconvenience works. An anti-suit injunction, maybe it's more obvious what an anti-suit injunction is because at least it's not in Latin. But what an anti-suit injunction is, it's an order restraining a litigant from commencing or continuing with proceedings in another country. So it's an injunction, it's an order of the court telling one of the litigants, you can't do this. Now it's directed, importantly, at the litigant. It's not saying to the other court, you can't hear this case, because no court in one country is going to say to a court in another country, you can't hear this case. That would be very rude, right? So it's directed at the litigant not to proceed in the other country's court. And if you directed at the litigant, it would be contempt of court to continue with the foreign proceedings. So even though technically that's right, it still feels to the other country like you're trying to bring our proceedings to an end. Because the whole point of it is to bring the proceedings in the other country to an end. So the owners of B Oceania actually applied to the court for an anti-suit injunction against the Chinese owner of Xintai Hai. Now, as I've said, that order would have been was directed at the Chinese owner of Xintai Hai. But it feels awfully like disrespect to the other country's court, because if that injunction is obeyed, the Chinese court now is not going to hear the case anymore. And so although technically it's not directed at the foreign court, it feels a lot like that. And so because it feels disrespectful to the other country's court, a court will only grant it in a clear case. And remember, once again, civil law countries won't do this at all. Common law countries will only do this in a clear case. And as I've said, the Australian court, the B Oceania actually asked the Australian court to issue an anti-suit injunction, and it did. It being the Australian court did grant an anti-suit injunction, right? Why did it do that? Well, the owner of Xintai Hai intended to ask the Qingdao Maritime Court to order the return of the security, the P&I Club undertaking. So in order to have the ship released from arrest in Australia, the P&I Club had given an undertaking to the Australian court. And then the owners intended to ask the Qingdao court to order that it be returned. And the Australian court said, no, wait a minute. If the Qingdao Maritime Court does that, it's interfering with our proceedings, because that undertaking was given in the Australian court. And if a Chinese court says it should be released, then that's interfering with the Australian proceedings. And so the Australian court said, don't do that, Chinese owner of Xintai Hai. We are going to issue an injunction preventing you from doing that in China. Okay? Now, I said, this may seem rather complicated to you, and this stuff, to be honest, perfectly is quite complicated, but this shows you what you can do in these cases if you're not in a convention country. And of course, China is not, the United States is not. So to sum up, I've got 2 slides to go and 5 minutes left, I think, of this class. What we're talking about is fighting about where you're going to fight. And as I said, this is intellectually very stimulating for the lawyers. It's probably good for the lawyers' billing. But it's not anything to do with the merits of the case. You're just fighting about where you're going to fight. But that's a really important thing, because if this case ended up getting fought in China, the amount of money that was available to be Oceania would be very different than the amount of money that would be available in Australia. So fighting about where you're going to fight is important in these cases. Now, as I said, the Australian court, oops, I go back to my larger thing here. The Australian court said that the Chinese court order would interfere with Australian proceedings. And I think that's right. That was the whole point of what the Chinese ship owner was asking the Qingdao Maritime Court to do, make them give back that thing that they gave in Australia. But the Australian anti-suit injunction interfered with the Chinese proceedings, because it says to the Chinese owner, you can't seek that order in Chinese court. So in a way, what was going on in this case, because China's not a convention country, Australia is, there's no treaty obligations between those two countries, each country ends up fooling with the other country's legal proceedings. Now, in a common law country, it is possible to ask for something called, believe it or not, an anti-suit injunction. And what an anti-suit injunction is an order restraining one of the litigants from seeking an anti-suit injunction in the other country. Now, it may sound to you like we're getting ridiculous now, but trust me, you can ask for an anti-suit injunction. Now, if Shin Tai Hai had been in a common law country rather than China, so if it had been in Hong Kong, for example, it could ask the court to restrain the owner of B Oceania from seeking an anti-suit injunction. And that is possible in a common law countries. If you think that the owner in the other country is going to try and restrain you from doing something in your proceedings by getting an anti-suit injunction in that country, you can get an injunction in your country restraining them from doing that. And I don't know if you're still following all of this, because it may seem like we're disappearing into nowhere, right? But that is what an anti-suit injunction is. Now, as I put at the bottom, you may have had enough by this point. We've been sitting here for an hour and nearly 20 minutes, so the class is nearly over. This may seem like it's become really ridiculously complicated. And to be honest, some of this is. And by the way, in case you're wondering, there's no such thing as an anti-suit injunction, because it's just an anti-suit injunction. You can't keep on going forever. There's either anti-suit or anti-suit, right? Now, because I have to draw to a close, because I know this class is about to finish, I go to my last slide, which is the conclusion, which you'll be happy to hear. It's not going to take me very long. And it explains why all the fighting that gets done in these cases, the fighting about where to fight, is done about limitation. Because there's not much difference in the law of different countries about the liability for the collision. Responsibility for the collision is going to be decided by the collision regulations. Like I said, give way to starboard, overtaking ship to stay out of the way of other ship. Those regulations are the same throughout the world. Why? 160 countries have adopted the collision regulations. China has, the United States has, Australia has, everybody's adopted the collision regulations. So the law about liability, who's liable, who is at fault, is going to be the same pretty much wherever the case is litigated. The difference between countries is in how much can you get. Because as I've tried to show you, that can be very different between different countries, depending on the different limitation regimes. And because it's the limitation amount that differs between different countries, That's why the ship owners and their insurers have an incentive to use the limitation proceedings as their means of selecting where to fight. Now, I have been in share screen mode for most of the talk. I now put it back into non-share screen mode to see whether there are any questions. Now I can, by the way, mute everybody else, I think. There's one other. So now I should appear in speaker view. Perhaps I do, perhaps I don't. No, I don't. But in any event, I know this class is only supposed to last for an hour and 20 minutes, but if anybody does have any questions, I'll try to take questions. I realize this is not the best format for receiving questions, but if anybody has any questions that you can communicate through this means, I'll answer them. If not, that's what I have. I chose this topic because it's a very international topic, and this is International Week in Dalian. So it's a very international topic, and it's about sort of battling this sort of international battle about where you're going to fight a case about a collision. It is fairly complicated law, but I hope I've made it fairly possible to understand what's going on. You're muted. You're muted. You've got to unmute. Oh no, I've got to unmute you. I get it. I get it. I get it. Sorry. Whoops. There we go. Now you should be able to unmute.